Hello, folks. Todd Halleck here, talking to you a little bit today about estate planning and the different kinds of estate planning that are available to you as an individual. There's many different routes that individuals can take in planning their estate with the ultimate goal of having your assets passed to living people after you have passed away. The first approach is really what we call the government plan. That's the plan where you don't take any affirmative action. You simply allow the assets of your estate to pass according to whatever your particular state has determined will happen upon the death of an individual in your situation. Does it all go to a surviving spouse? Is that change if there's kids that aren't from that marriage? A lot of different ways that different states approach it. They're intended to be generally applicable. They're not necessarily considered as to your specific situation. And so you really just defaulted and said, whatever the state has said, that's what I'll go with. You will go to court and the judge will decide who's in charge and will ultimately apply that state law in determining where the assets will go. The next level above that is one that probably most people have at least engaged in, and that's some assets allow for beneficiary designations. And so you list my wife as the beneficiary of my insurance policy, or my daughter as the beneficiary of my retirement account. And upon your death, the contract between you and the company that owns that account or manages that account will provide that it will pass directly to those individuals upon your passing. There's no need for probate. There's no executor or representative or trustee or anything like that necessarily appointed. It just automatically passes to the individuals you've designated. A close cousin to that would be a title-based plan where you identify in the title that you own it jointly with someone who automatically receives it upon your passing. That could be on real estate, joint tenancy with rights of survivorship. It might be in a bank account. Similarly, again, it automatically passes to the co-owner. So for example, if you and another individual own a bank account together jointly with rights of survivorship and you have a death beneficiary, in the first instance it's going to go to the co-owner of the account, and in the second instance, when there's no longer a co-owner, that's when it goes to the beneficiary. Again, no probate is necessary in that situation, and no representative or executor is appointed to manage that necessarily. The first sort of real step that people might take into planning is for doing a will, last will and testament. There's our testamentary instrument as opposed to dying intestate without a will and having the government plan control. The testamentary instrument, the will in this case, will say this is who I want to be in charge and this is how I want my assets to be distributed. And absent some rare occurrence, the court will apply your wishes at your passing. They are death instruments, and so they aren't going to be effective until you pass away, and they're not going to be able to be used to manage your affairs while you're alive, but enabled to manage your own affairs. And so purely a death instrument, definitely involving the court. In fact, in most states, if you haven't probated the will within a certain number of years after the death, it becomes a nullity and you're back to the intestate situation. So sometimes people will want to probate that will, even if things are otherwise passing without, just to lock in the beneficiary structure of that will. The next step up is going to be a trust-based plan. There's a lot of different varieties of trust, but the most common designations that we would say is it's a revocable trust or an irrevocable trust. And then within those, there may be a lot of different ways that you go with your plan. A basic trust is very similar to a will-based plan in that the goal is to provide for the orderly transfer of assets at your death. You nominate who's going to be in charge of that transfer process and who's the recipient of those of those gifts upon your passing, the beneficiaries, and the main difference being that With the trust, you generally don't have to go to probate. You establish the trust as the trustor or the grantor. You are the trustee often in that situation, and you are also the beneficiary. And when you pass away, or if you become disabled, the person that you appoint simply steps in and takes over for you without the need of court intervention. And like I indicated, the other difference is that it's effective while you're alive, not just after death. So it can oftentimes help you to avoid the need for guardianships or conservatorships as well. So it can be a really great tool that way. Revocable trusts, you can amend, you can change at will, move things in and out of. They're really disregarded for all purposes except for those that we've just been talking about. If you get into irrevocable trusts, those can be much more difficult to change, tend to be very static. They're usually done for a specific purpose, and doing it for one purpose will usually run contrary to other purposes. So it's not, irrevocable trusts don't tend to be one size fits all. They tend to be, what's the stated goal that you're trying to accomplish? Is it asset protection? Is it trying to qualify for Medicaid at some point? Is it taxes? What's drawing you into needing that irrevocable trust? And then that will dictate how that trust is drafted in large measure. But the effect is the same overall, is that we're providing for the transition of your assets when you're not around, and we're doing so outside of the probate system. So, whether you do a will, a trust, beneficiary designations, certainly having some type of plan in place is crucial. The worst place to be is no plan. The second worst place to be is having assets like retirement accounts or life insurance policies that could have beneficiary designations and now have to go through probate because you didn't name one. So I'd encourage you to get in with your good qualified estate planning attorney and have that person help you figure out which plan is going to be the best fit for you. Pretty sure it's probably not the government plan, but you never know. But I hope you found this useful in your learning about estate planning and what the different options are. Have a great day.